All right, and Mr. Hardwick, I need you to come into camera. Please accept to join the breakout room and wait for the lawyers to come in to speak with you. Do not leave the breakout room until I only need Mr. Hardwick in the camera, please. Do not leave the breakout room until someone has come in to speak with you. All right, are we ready?
Yes, Your Honor. May I advise the court with regard to Rashad Pack?
I guess so.
Mr. Pack is actually in having dialysis right now that is scheduled to conclude about 10:20. Could he zoom back in at 10:30 for his arraignment?
Yes.
Okay, thank you, Your Honor.
Good morning, counsel.
Good morning, Your Honor.
You're here for Mr. Benavides.
Yeah, I'm standing in for Brent.
You're standing in for who?
Brent Jaffe.
Right. You're standing in for Mr. Jaffe.
Correct.
Okay. All right, I'm ready on Benavides, case number 214540901, the people of the state of Michigan versus Christopher Benavides. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for an arraignment. Appearances, please.
Good morning, Your Honor. Christina Ritter on behalf of the people, P number 83505.
And good morning, Your Honor. Attorney Scott Colassa standing in for Attorney of Record Brent Jaffe, P84583, on behalf of Christopher Benavides, who is present via Zoom.
Mr. Benavides, please state your full name.
Christopher Craig Benavides.
Thank you. Today is the date set for an arraignment. Counsel, how are we proceeding?
Yes, Your Honor. We do waive formal reading and stand mute.
Court enters a not guilty plea. On behalf of Mr. Benavides, sets the matter for a pretrial conference. Mr. Flanagan, did I already overbook myself for the 15th of March?
23 that day so far.
Council is March 15th. A good day.
Yes, that would work.
Court sets the pretrial conference for March 15th. At 8:25, Esteban.
Yes, Your Honor. Mr. Benavides has retained counsel, and all his ties are to the state of Michigan and the Tri-County area. I believe he is employed, and for those reasons, we would be asking for bond to continue on a personal bond.
You said bond to continue. He doesn't have a bond.
Oh, I'm sorry. I'm sorry, for a personal bond, Your Honor.
Ms. Ritter. You're muted, Ms. Ritter.
I'm sorry, Your Honor. The people have no objection to a personal bond. We are asking for no contact with the complaining witness, Mr. James Jaron.
The court will set bond in the amount of $2,000 personal bond. No contact with the complaining witness. Anything further?
No, thank you, Your Honor.
Yeah, Ms. Ritter, how should we go about getting discovery?
Judge, did the court order discovery?
I did not. It's
Oh.
the arraignment, but I did not.
Okay.
Contact Ms. Ritter through the Bar Journal Council.
Thank you.
You're welcome. All right, everyone, have a great day. Stay safe.
You too.
Thank you. Ms. Ritter, are you aware of Angelo in?
Yes, Your Honor. He is I'm sorry.
Go ahead.
He is the complaining witness for Roscoe under 8:30. Should I tell him to come back? Was that the one that's supposed to come back at 10:30?
No, that's Mr. Pack.
Oh, okay.
Did you want to speak to him?
Very briefly, Your Honor.
All right, are we ready on Brown? Let's see. We're ready on Brown.
Ready on Brown, Your Honor.
Mr. Swaggerty, I'm going to send you to a breakout room. The prosecutor is going to come in to speak with you shortly. Please accept to join the breakout room. Ms. Brown, please start your camera. All right. I'm ready on Brown. This is case number 234454301. The people of the state of Michigan versus Shakira Irene Brown. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Shakira Brown. Ms. Brown, on behalf of Ms. Brown, Your Honor, we move for dismissal for the complainant's failure to appear.
Can she state her name?
I'm sorry, Ms. Brown, please tell the court your full name. I apologize, Your Honor.
My name is Shakira Irene Brown.
All right, today is the date set for pretrial conference. Ms. Ritter, your response to the defense motion.
Your Honor, I do not see the complaining witness, Ms. Shanice White, in the waiting room. However, it is a first-time pretrial conference. Respectfully asking the court to adjourn the pretrial conference and give Ms. White one more opportunity to appear.
The court is going to deny defense counsel's motion to dismiss, grant the people's request for a one-time adjournment, giving them an opportunity to locate and notify the complaining witness of the obligation that they appear before the court. The matter is adjourned to March 15th at 8:36. The complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complaining witness could not appear or should not be required to appear. Bond will continue with no contact with the complaining witness. Anything further?
No, thank you, Your Honor.
Nothing on behalf of Ms. Brown. Thank you, Your Honor.
All right.
Thank you.
Brown,
Thank
you're
you.
all set, and have a great
All right.
day. Stay safe.
Thank you. Thank you all, and be blessed. Bye. And you too. Thanks. Bye.
I'm ready on Finney, and then, oh, let me call Judge Gary. Hold on. Miss Ritter, you could go in the breakout room while I call Judge Garrett.
Thank you, Judge.
All right.
Not that it matters, just curious.
Miss Stevenson,
Yes, Your Honor.
with respect to Finney, what's the alleged relationship between the parties on the domestic violence charge?
Siblings, Your Honor.
Oh,
Oh.
siblings. Okay, hold on. All right. Whose child is it then?
The
Defendant's child?
I don't know that answer definitively. I think it's the I don't know the answer to that, Judge.
So, okay, but the two people that the charge where they're charging domestic violence is between siblings.
Correct, Your Honor. They're sisters.
Okay, thank you.
You're welcome. Ms. Ritter, it looks like those are the defendant's children or child.
Okay, I'm ready on Finney and we're gonna send it next door. So, Mr. Flanagan, you could take the file next door, and Ms. Stevenson, you all can let your colleagues know. Ms. Ritter, you can let your colleagues know.
Okay.
All right, so this is case number 194614401, the People versus Sienna Marie Finney. Defendant is charged with child abuse, 4th degree, and domestic violence. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Sienna Finney. Ms. Finney, ma'am, please unmute and say your full name.
Sienna Marie Finney.
All right, today is the day set for pretrial conference. Of course, we've had some off the record discussion, and I just spoke with Judge Austin Garrett. We both agree that the case, the main charge, if we could look at it like that, is the domestic violence charge. And so we're gonna send it next door to Judge Austin Garrett. Judge Garrett is expecting you, Ms. Finney. Mr. Mosby has come out without a plus sign. Did you all talk to him?
I'll verify that, Your Honor.
Okay. Ms. Finney, how did you log into my Zoom this morning? Did you use the Zoom ID number, or did you click on my name on the court's website?
I used the Zoom ID number.
All right. So Judge Garrett's Zoom ID is identical, except where you see a 9, you change it to an 8. So it's just one number difference. Instead of a 9, put in an 8. They're expecting you, so you can go ahead and log into his courtroom, okay?
Okay, thank you.
All right, you're welcome.
While I'm waiting for a response from Ms. Hall on Mosby, I spoke to him previously, so if he's ready for court, he can go into the waiting room.
Okay, I don't know if he's ready or not.
Okay.
But all right. Okay, it's a lot of people coming out without plus signs. Can you ask Miss and can you take off your hat, Mr. Hardwick? And I don't think Mr. Hardwick spoke to a lawyer. Did you speak to a lawyer, sir? Unmute yourself.
Have anybody came on there, ma'am?
Well, I told you to wait there until they came. That's exactly what I said. I said, wait in the breakout room until a lawyer comes in to speak with you. Please do not come out of the breakout room until you have spoken with a lawyer. Please return to the breakout room. Are we ready on Howard
Ready on Howard, Your Honor.
and Rasco?
Let me see if
I don't see if
Rasco is
Rasco
out.
is here.
Rasco is still being interviewed.
Okay. And then I need to get ready all the way on Meriwether. I need Clemmy Howard to start your camera. And then Mr. Lingenfelter, can you start your camera? This, oh, he's driving. Okay, we're gonna put him back in the waiting room. He needs to pull over. All right, this is case number, 234570301, the people versus Clemmy Lee Howard. The defendant is charged with 1 count of failing to stop at a property damage accident. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people, and the complaining witness, Mr. Derek Lingenfelter, placed back in the waiting room. Judge, it looks like he's driving, but he may be pulling over.
All right.
For the record, Your Honor, Janice Stevenson appearing on behalf of Mr. Clemmy Howard. Mr. Howard, sir, please unmute and just say your full name, sir.
Unmute. You have to unmute, Mr. Howard.
All right, you hear me now?
Did you unmute?
Yes.
Okay, well then we hear you.
Okay. Clemmy Lee Howard.
Thank you. Today is the day set for a pretrial conference. How are we proceeding?
Thank you, Your Honor. Mr. Howard will continue his plea of not guilty. We'd ask that the matter be set for final pretrial conference. We would request discovery.
Today is the day set for pretrial conference. The complaining witness is present but driving and unable to attend court at the moment. Court will note that earlier the complaining witness did have on his camera and he was not driving. He was stationary as is required by the court. Court will continue a not guilty plea on behalf of Mr. Howard. Set the matter for a final pretrial conference. April 17th. Mr. Flanagan, how many do I have? April 17th.
Six.
Court sets the matter for April 17th. At 9:00 a.m. Discovery should be submitted to the defense by March the 18th. Bond will continue with no contact with complaining witness. Anything further?
Nothing from the people, Judge. Thank you.
Nothing on behalf of Mr. Howard. Thank you, Your Honor.
Mr. Howard, then you're all set, sir. Have a great day. Stay safe.
All right, you too.
Thank you. Are we ready on, oh no, they're not here. Mr. Flanagan,
Yes, Your Honor.
can you call the attorney on Ross and find out why we're waiting on them and their client?
Yes, Your Honor.
Thank you.
May I step away just for a moment, Your Honor?
I suppose so. Yes. I don't see this person in the waiting room. Okay.
go.
Mr. Rasco, please start your camera. This is case number 234571601, the people versus Henry Williams Rasco. Defendant is charged with assault or assault and battery. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people. I have the complainant witness present via Zoom this morning. Mr. Swaggerty, unmute yourself and state your name for the court, please.
Sir, please unmute yourself. Please unmute yourself.
Sorry about that, ma'am. That would be Angelo. Last name is Swaggerty.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Henry Rasco. Mr. Rasco, sir, please unmute and say your full name.
Okay, I don't know why y'all want, okay.
Henry Rasco.
What's your middle name, sir?
I'm sorry, Henry William Rasco.
Today is the date set for pretrial conference. How are we proceeding?
Thank you, Your Honor. Mr. Rasco will continue his plea of not guilty. We would ask that this matter be set for final pretrial conference. We would request discovery, Your Honor.
Court is going to continue a not guilty plea on behalf of Mr. Rasco. Set the matter for final pretrial conference, April the 17th at 9:00 a.m. Discovery should be submitted to defense by March the 18th. Bond will continue with no contact with complaining witness. With respect to the April 17th date, Mr. Swaggerty, you have appeared today. Therefore, your appearance is not required on April 17th. However, you may appear, should you choose to, as the complaining witness. Of course, you can appear at all scheduled court appearances. Anything further with respect to Mr. Rasco?
Not from the people, Judge. Thank you.
Nothing on behalf of Mr. Rasco. Thank you, Your Honor.
All right, gentlemen, you're all set. Have a great day and stay safe.
Thank you.
Welcome.
Yes, ma'am.
Are we ready on Mosby?
Ready on Mosby, Your Honor.
Well, how did, okay. Mr. Mosby, please start your camera or I'm going to pass your case.
I'm sorry, Your Honor.
I'm sorry too. Let's go. This is case number 204529001. The people of the state of Michigan versus Walter Mosby III. Defendant is charged with 2 counts of malicious destruction of property. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Walter Mosby. Mr. Mosby, sir, please unmute and just say your full name.
Walter H. Mosby III.
Today is the date set for pretrial conference. How are we proceeding?
On behalf of Mr. Mosby, Your Honor, we would move for dismissal for the complainant's failure to appear.
Ms. Ritter.
Your Honor, I don't see the complainant witness, Ms. Rosalind Woodall, in the waiting room. However, it's scheduled as a first-time pretrial conference, and it is from 2020, Judge. So I am asking the court to adjourn the pretrial conference to see if to see if the people can locate the complainant witness to see how we will move forward in this matter.
Court is going to deny defense counsel's motion for dismissal, grant the people's request for a one-time adjournment, giving them an opportunity to locate and notify the complaining witness of the obligation that they appear before the court. Ms. Flanagan, how many do I have on April 2nd, please?
'21, Your Honor.
That includes both bench trials. Both three jury trials, correct?
Yes.
All right, the court is going to set the matter for April 2nd. At 8:36, the complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complaining witness could not appear or should not be required to appear. Bond will continue with no contact with the complaining witness. Anything further?
No, thank you, Your Honor.
Nothing on behalf of Mr. Mosby. Thank you, Your Honor.
All right, we're all set. Mr. Mosby, until April the 2nd, have a great day and stay safe.
You too.
Thank you. Good morning, Ms. Farage.
Morning, Your Honor.
Your client isn't present.
That is correct, Your Honor. I've been having some trouble trying to get a hold of him this morning. I do know that he has a lot of different phone numbers that he calls me from due to his inability of having, I believe, like a cellular phone plan. It only works on Wi-Fi.
Okay.
Would Your Honor be able to allow for us to see if I can get in touch with him before the end of the day, before issuing the warrant? I know we're not on the record yet.
Say that last part again. I'm sorry.
I apologize. I said, would Your Honor, I know we're not on the record yet, but would Your Honor allow for me the end of the day or the end of the business day before issuing a warrant out?
Well, I don't think he's capious before. Mr. Flanagan, has he capious before?
Yes, Your Honor.
Oh. When did he capious?
September 11th, 2023, from a pretrial.
All right, so yeah, I'll give you until the end of the morning docket, not the end of the business day. So he has until about 11 o'clock to 11:30, and then I'm gonna issue the warrant.
Thank you, Your Honor.
You're welcome. Mr. Hayes, we'll call you if he shows up.
11:30, you're gonna speed through this docket today.
Well, I'm being 12 o'clock probably, because I do have a motion hearing actually today.
All right, sounds good. Thank you, Your Honor. Appreciate it.
All right. Okay.
Thank you, Your Honor.
You're welcome. All right. I was doing something. Oh, are we ready on Nelson?
Ready on Nelson.
Hello?
Ma'am, don't do that. You're not on a telephone call. All right, this is case number 164413601, the people of the state of Michigan versus Tamara Tenise Nelson. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Rakidia Hall, P number 82954 on behalf of Tamara Nelson. Ma'am, may you unmute yourself and state your full name for the record?
Tamara Denise Nelson.
Today is the date set for a pretrial conference. How are we proceeding?
Your Honor, we are requesting a dismissal in the absence of the complainant. If the court is not inclined to dismiss this case at this juncture, we have no objection to an adjourned pretrial requiring the complainant to appear.
Ms. Ritter?
Your Honor, I don't see the complainant witness, Ms. Faith Nixon, in the waiting room. This is a case from 2016, Your Honor. I respectfully ask the court to adjourn the pretrial conference and give the people an opportunity to try to locate the complainant witness to see if we will move forward in this matter.
The court is going to deny defense counsel's motion for dismissal, grant the people's request for an adjournment, giving them an opportunity to locate and notify the complaining witness of the obligation that they appear before the court. I am going to adjourn the matter to April the 2nd at 8:36. The complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complaining witness did not appear or should not be required to appear. Bond will continue. Anything further?
No, thank you, Your Honor.
Nothing for Ms. Nelson.
All right, then we're all set, Ms. Nelson, until April the 2nd. Have a great day and stay safe.
Thank you.
You're welcome. Mr. Flanagan,
Yes, Your Honor.
do you have the Mayweather file? The Merriweather file?
Yes, Your Honor.
Can you look and see if there's a the full investigators report in there?
Yes.
Can you scan it to me or bring it to me?
Okay.
Thank you.
All right, I'll bring it up now, Your Honor.
Thank you. Okay, I don't have everybody highlighted. I'm ready on Graham. Three, 601, the people of the state of Michigan versus Gary Graham. The defendant is charged with child abuse, 4th degree, and assault or assault and battery. Today is the date set for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Gary Graham. Mr. Graham, sir, please say your full name.
Gary Graham.
How are we proceeding?
On behalf of Mr. Graham, Your Honor, we continue the plea of not guilty. We would ask that this matter be scheduled for jury trial. We would like to be heard as to bond, Your Honor.
Court continues a not guilty plea on behalf of Mr. Graham. I will set the matter for jury trial. Come on, Mr. Flanagan. All right, I need to wait for Mr. Flanagan to get downstairs.
Okay.
Do you have, on September 4th, do you have 2 trials, Hollins and McClendon?
I do. Well, I have Hollins. I don't know about McClendon anymore.
Well, for McClendon, I have a final pretrial is August the 2nd.
Okay, I'll check that out.
Mr. Flanagan, I should have told him to. Mr. Flanagan, are you there?
He's not back yet, Your Honor.
All right, let me know when he gets back.
Yes. Back.
Oh, he's back now?
Yes.
All right. Ms. Flanagan, when you get situated, pull up September 4th for me.
Okay. Okay, it's pulled up, Your Honor.
I have Hollins and McClendon at, what do you have? Jury trials.
Yes, I have them both as well.
Are they the only 2?
Yes. Mm-hmm.
And then I have McClendon's final pretrial conference is August the 2nd. Is that what you have?
Going there right now. Yes.
All right. I'm going to set this matter for jury trial September the 4th. At 10:30, of course, with the final pretrial conference. August 2nd. Feel like that's not a good day. Hold on. Oh yeah, I don't know why I'm putting stuff on August 2nd. I need to move those final pretrials to, July 31st. I need to move McClendon to July 31st. All right. And then I'm gonna set this one also for July 31st. With respect to the people, on the count 2, when is the last time the complainant appeared?
So, Your Honor, with respect to count 2, the complainant witness is the same
That's
complainant
count
witness.
1?
Mhm.
Oh,
I'm assuming the count 2 is just a lesser included offense.
all right. I need the people to confirm on July 31st the availability of that witness. Then how old is the witness?
So at the time of the offense, the complainant witness was 12 years old.
But it's a 2000 and, oh, well, 22,
Okay.
so
So he may be 13 or
maybe
14.
13 or 14. And then September 4th, that's gonna be right. School would have just, that might not be a good day. They'll be back in school. So let's change that. Mr. Flanagan, can you tell me? Hold on, let's see. What are the jury trials that I have on August 20th? I have Saeed and I have Ahmad, but I have that you told me I should have 4.
Yes. Ahmad, Ford,
Wait a minute, Ford, Ford, what's the first name on Ford?
Simone.
And who was the lawyer?
That's the one that's in pro per, Your Honor.
Oh. Oh, all right. When is her final pretrial conference?
July 9th.
When is Ahmed's final pretrial conference?
August 7th.
All right. And what's the 4th one?
Danny Kaji.
Who's the lawyer?
MFD.
When is the final pretrial?
July 10th.
All right. Okay, school starts back. All right. I might have to move that later. let's. All right, I'm gonna change it. I'm gonna change this. So I'm going to actually set the final, I am gonna set the final pretrial conference for July 31st. And what I'm gonna do is I'm gonna hold on, let me put it back. So, Ms. Ritter, I'm gonna set it for jury trial September 4th. Tentatively, I'm going to set the final pretrial conference for July 31st. What I want is for the parent guardian of the complaining witness to appear so that we can actually see if that's a good trial date. And then if not, where we could pick a trial date, because the child will probably that'll be like the second day of school. And I don't really want to do that unless they go to a school that starts earlier. Some schools still start before Labor Day, I don't know, private schools, or I don't know if some charter schools, but I don't want to pull a child out of school the second day back. So the final pretrial conference, July 31st, parent or guardian should come so we can actually pick a good day. They should come with the dates for the winter break, that they get. Because if we don't do it in September, then I want to do it right at the winter break, like at December. So final pretrial July 31st at 9:10. The September 4th trial date is a soft date. That's a soft date. And then depending on some of those trials that are scheduled at the end of August, we might be able to put this on one of those. So let's keep that in mind. So I might be able to put them in August if some of those other trials settle. So let's go with July right now for the final pretrial, with the thought that the trial is probably going to be either August, September, or December. Okay?
Yes, Your Honor.
Anything further?
No, thank you, Your Honor.
May we be heard as to bond, Your Honor?
May.
Thank you. So Mr. Graham is absolutely interested in the earliest trial date possible so that this matter can be resolved. The child, Imari, is currently in foster care at this time. Because of this court's no contact condition, Mr. Graham believes, he's having a little bit of trouble on the other end, that the possible reunification plan may be on hold. So I'm asking for no assault of contact, just to facilitate any type of supervised visits they're trying to work out with the foster care, Your Honor.
What is the relationship between Mr. Graham and the complaining witness?
Father and son, Your Honor.
Oh, all right.
Judge, I'm sorry, that's not what the information I have. It looks like it's nephew and uncle.
So, could we go to breakout, please? This is some pretty private information.
Sure.
Thank you, Your Honor.
All right. So with respect to the request for the modification of the bond condition, at this time, the court is denying the modification of the bond condition pending, so actually, Ms. Stevenson, it could be, if you get confirmation to Ms. Ritter, if Ms. Ritter speaks to them, because she has to notify them now of the court date, if she speaks to them, we don't necessarily have to have a bond hearing. But so if Ms. Ritter speaks to them, or
Okay.
get something to Ms. Ritter and she agrees that there is a plan in place or trying to be put in place, then I'll, with the people's consent, I'll modify without a bond hearing. But if the people don't consent, then we have to have a bond hearing.
Thank you, Your Honor.
All right, you're welcome. So right now we're all set until July 31st, unless there's an interim bond hearing. If there's any issue, and then Ms. Stevenson, to facilitate that, if you can get the specific worker's phone number, contact information for Ms. Ritter, that'll make it easier.
I agree, Judge. Thank you.
Understood.
All right, anything further?
No, thank you, Your Honor.
Nothing for the record. Thank you, Your Honor.
All right, then we're all set. Did you need Mr. Graham to wait for you in the hall, or is he all set to go?
Mr. Graham, I will give you a call later this afternoon. So you can either wait for me in the hallway, or I can call you this afternoon, whatever you prefer.
Yes, ma'am.
All right. Okay, we have a complainant on Meriwether, so I'm gonna go ahead and do the sentencing. Sir, you're all set. This is case number 234508201, the people of the state of Michigan versus Heather Meriwether. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people. From my understanding, the complainant witness is in person this morning. I don't see her, but if she could stand, oh, there she is, Judge. Ms. Griffin, can you state your name nice and loud for the record, please?
Betty Ann Griffin.
Ms. Stevenson, come on.
For the record, Your Honor, Janice Stevenson appearing on behalf of Heather Merriweather. Ms. Merriweather, ma'am, please unmute and say your full name.
Heather Merriweather.
What's your middle name, Ms. Merriweather?
Heather Marie Merriweather, I'm sorry.
Thank you. Today is the date set for sentencing. The court has had an opportunity to review the pre-sentence report. And with respect to the report, are there any additions, deletions, or corrections on behalf of the people?
Judge, the people had an opportunity to review the pre-sentence report. I don't see any additions, deletions, or corrections on our end.
On behalf of Ms. Merriweather, Your Honor, we've had the opportunity to review the pre-sentence investigation report, and we do offer the following correction. Well, actually, Your Honor, at this time, we have no additions, corrections, or deletions, and Ms. Merriweather does stand ready for sentencing.
With respect to sentencing, anything on behalf of the people?
So, Your Honor, there was a plea agreement for a recommendation of a term of probation, 24 weeks of anger management, no contact with the complaining witness, Ms. Betty Griffin, and restitution for any medical out-of-pocket expenses that Ms. Griffin may have incurred in result of this incident. And on page 4, there is a victim statement from Ms. Griffin. And she is in person today, Judge, so I would just defer to Ms. Griffin if she would like to make a victim impact statement orally to the court. However, I don't see any restitution information, and I'm looking through my notes, Judge, and we didn't receive any restitution information, so I would defer to Ms. Griffin if there is any medical expenses that she has that could be tendered to the people so that we could see if it qualifies for any restitution. And at this time, Judge, I would turn it over to Ms. Griffin if she would like to make her victim impact statement to the court at this time.
Ms. Griffin, did you want to make a statement to the court?
Yes, Your Honor.
Come up to the podium, please. Ms. Griffin? Ms. Griffin, also, I'm in the building. Did you want me to come downstairs so that you could talk to me in person, or are you okay looking at the screen? I am in the building.
I'm okay looking at the screen, Judge.
Okay. All right. Go ahead, Ms. Griffin.
Your Honor, on that day, I was physically and psychological and emotional stressed. I had to stay away from my home for 2 months because I was fearful to stay in my home. I asked the court to send to them her and her sister the full extent of the court. Thank you.
All right. Thank you. Anything further on behalf of the people?
Nothing further at this time, Your Honor. Thank you.
All right. Miss. I'm sorry. Ms. Griffin, you can actually have a seat. You can go back and have a seat on the front row. Thank you. Okay. On behalf of the defense.
Thank you, Your Honor. So in the police description of the offense, the information contained there is consistent with that which is in the police report in terms of the location to which the police responded. But the police responded, actually, according to my client, they didn't go to 5978, the street name that's mentioned in that report. They went to 5960. And that's important because my client wants the court to know that she and her co-defendant are the parties that actually called the police out to the location. So unfortunately, there has been some acrimony between these neighbors. There have been prior police reports, Your Honor, and there have been prior allegations of property damage by the complaining witness. Those complaints have been made to the police, Your Honor. And on the date in question, I think that the report indicated that this all stemmed from this particular incident stemmed from the complainant allowing her pets to enter upon the property of the defendants. And my client's position is that that is absolutely incorrect, that the complainant actually had two animals at least tied to the defendant's fence. And those animals were in
defendant's
distress.
fence, or is it the
Yes.
Is it the
It's
common fence between the two properties?
it's on the property of the defendant. So it's the defendant's fence.
Is that what the law says? But let's go ahead.
Okay. So which is what caused my client, and I can't speak to the co-defendant, they have a different sentencing date coming up, which was what caused my client to go outside and come into contact with the complaining witness in the first place. So I am well versed in the law of self-defense and all that. And so having conferred with Ms. Meriwether, she having had the opportunity to get an understanding of what self-defense is and what self-defense is not. She did offer the court a plea of guilty and accepts responsibility for her actions, but we don't want the court left with the impression that that my client, left their house and took a broom to this person who is over 20 years older than her. That's not the way the incident happened.
Well, Ms. Stevenson, is your client, if your client is not going to address me, I don't know, but maybe you should, because this is the first time that I've ever requested the full police investigators report so that I can try to figure out what's going on and why an individual who is 20 years younger than a person would take a broom to their head. So at this point, somebody better tell me some more information or it's not going to be looking so good.
May I speak?
Not yet. No, ma'am. Ms. Stevenson?
As we anticipated, Your Honor. So that is the exact reason I'm getting a little bit more involved in the incident itself than I normally would at sentencing. So my client, the complaining witness and the co-defendant, who's not yet been sentenced, were engaged in a physical altercation. And quite frankly, Your Honor, I think it's in the police report. That altercation started by the co-defendant spraying water on the complaining witness, which is what causes. So my client goes outside to try to come to the aid of her sister when a fight ensues between the complainant and the co-defendant. And because the co-defendant is actually the person who started that altercation, we believe that a self-defense claim or a defense of others claim would fail. So.
And I'm so sorry, Ms. Stevenson, I hate to interrupt. I do apologize to the court, but Judge, I would just object to Ms. Stevenson getting into the facts involving the co-defendant, because actually I don't even think that co-defendant has been set for sentencing. I don't think they took a plea.
But that don't have nothing to do with this.
Okay. Okay.
So for those reasons and some others, we decided that the best, the most lawful option would be to go ahead and offer the court a plea of guilty. But Ms. Meriwether did not leave her home. She didn't come outside of the house even to aid her sister armed with a weapon. It is her position that at the time of the incident, during another altercation, that the complaining witness lunged at her, and that's when Ms. Meriwether struck the broom. Is that okay? Absolutely not. It isn't. And that's why Ms. Meriwether did offer the court a plea of guilty. But we don't want she indicates that Ms. Meriwether indicates that after she struck the complaining witness, that the complaining witness actually did come at her. The two of them did engage in a physical altercation, wherein Ms. Meriwether was on the ground. Ms. Meriwether denies, any biting or anything like that. So there is volatility between these parties. Ms. Meriwether's response was inappropriate. She is here to take responsibility for her actions. We're not going to object to, actually, it was the plea agreement, an extended period of anger management. I did want to just point out that in the pre-sentence investigation report, I think in the evaluation section, it indicated that Ms. Meriwether appeared to show a lack of remorse. And I wanted to get under that in preparing for sentencing today. And her expression to me was that she is very remorseful. She'll explain that to the court. But her affect may be dulled a little bit by the fact that this has just been an ongoing problem with this neighbor, that it's just been so much back and forth. And she is very, very, very frustrated with the situation. And for that, the longer anger management course probably is in order. So we just don't want the court left with the impression that my client kind of leaves out of the house and starts swinging at this woman with a broom and goes upside her head or anything like that, because the facts just are more complicated than that. The end result, which is why we chose to offer the court a plea of guilty rather than proceeding to trial, is that Ms. Meriwether should not have, she misjudged the situation in moving out. She believed initially to aid her sister, that had she known that things were not the way she perceived them, she may have engaged in a different course of action. And she has expressed remorse to me. I hope she will do that to the court this morning about the entire situation, about placing herself in the position that she's in right now. And she's ready to make amends, Your Honor.
Okay, before I move to your client, didn't we, Miss Rivers looks like I saw, did you all speak to Miss Rivers?
I had a plus sign initially before Miss Rivers. She left and came back, but I recently got some information that I want to share with her, which is why I didn't put the plus sign on back in front of her name, Judge.
All right. Those who I've just let in the courtroom, please accept to join the breakout room and wait for the lawyers to come in to speak with you. Do not leave the breakout room until you have spoken with a lawyer, and please do not request my assistance in the breakout room. Wait in the breakout room until the lawyers come in to speak with you. All right. All right, would Ms. Meriwether like to address the court?
Yes. I regret my actions. It was totally out of character of me. I've never been in any trouble. I've never been in any fights. It's just a situation that got out of hand. I'm not a violent person. I have never been arrested. This is my first time being in a fight, being in an altercation with anyone. And this whole situation is it saddens me. It just saddens me because I've never been in trouble before. I've never been arrested before. I've fought 41 years of my life. I've never been arrested. Never had any issues with anyone. It just the situation just got out of hand. And it wasn't, Oh, am I muted? No.
No, you're talking. We hear you.
Yeah, this situation, it was just a sad situation because we've been neighbors with her. We've had troubles with her in prior years. We had trouble with her that summer. She had torn down our fence on the left side of our property, and we called the police for that. That's what led up to the whole situation. The whole situation with the incident is she tore down the fence on the left side of our property. So it was a wrought iron fence. She pulled that up out the ground. And so we called the police on her, and the police came out. They really didn't do anything about the situation. So when we saw her on the right side of our property, she lives on the left side of us. She was all the way on the right side of our property that day. And then she started to break off pieces of our wooden property fence. And then she was tying doggy pads to the fence as well. She had a cat tied to the fence. She had her elderly dog on our grass, and she was breaking off pieces of the fence. And that's what caused my sister to go outside to spray her, tell her to get off the property. And I heard I was yelling from the inside of my home, so I came out to see what the problem was, and that's what my sister and Betty Griffin was in an altercation. My intentions were never to go out there to fight her. That was never my intentions. I was going out there to, if you hear yelling and your family members outside and they're yelling and arguing, naturally you're going to go outside to see what's going on. So I went outside to see what's going on, and my sister sprayed her because she refused to get off the property. And she was saying, this is not your property. It's not your property, but it is our property because it was all the way on the right side of our house. Betty Griffin lives on the left side of the property. She was on the right side, all the way to our fence on our property line, and that's where she tied her animals. So it was in fact our property. It wasn't a shared gate at all. Her house is on the left side, and our house is on the right, and she was all the way on the right side of our property. So it is our property. It wasn't a shared space. So it wasn't just like, we just came out there to beat up on an elderly woman. We had problems with her in the past. We've never had any problems with our neighbors before. None of us never have been arrested. None of us never have been in a fight. So it's just a very unusual situation that we find ourselves in, a very unfortunate situation. We're not violent people. My sister have never been arrested. My sister have never been in a fight. I have never been arrested in a fight. We mind our business. It just, because of the prior history, that's why it escalated the way it did, because of our prior history. It wasn't that today we decided that we was going to beat up on somebody. It was an escalation. She was actually antagonizing us by putting her animals on our property, because for what happened the first time, but the police didn't do anything about it, she antagonized us by coming on our property and putting her animals on our grass, and tying doggy pads to the fence. So we're not violent. We're not violent people. I'm not a violent person at all. It's just an unfortunate situation that happened.
Give me. Oh, I'm sorry. I apologize. I thought you were finished. Go ahead.
Sorry, I just regret the whole thing. I am very remorseful. It's embarrassing, and because nothing never has happened like this before. Nothing has never happened to me like this before. I've never been arrested before. I'm just really sad, and I'm just very sad about the situation.
All right. Give me one moment. I need to speak with the judge. Give me one moment. All right, I'm ready. Please excuse the interruption. All right, so the court has had an opportunity to review the pre-sentence report, the investigator's report, to hear counsel, to hear the victim, and to hear from the defendant. I usually say I'm ready to impose sentence, but I'm not probably all the way ready, but I'm going to go ahead and impose sentence. And of course, we all probably, know that I'm disgusted by this, that this is not right. And I understand Ms. Merriweather is saying that she's never been in trouble before. The situation got out of hand. Ms. Griffin is coming not on the property that abuts, not on the common property line, but she's coming on this other side. And the law, there are special laws for a group of people, for groups of people. There are special laws. There are laws when adults injure children, and then those are usually and generally child abuse, right? There are those laws. There's a whole set of laws for the protection of children. And then there's a whole additional set of laws for the protection of seniors. And you just don't treat a senior the same way you would treat people in between. So if a person in between is coming on your property, tearing down your fence, you still don't beat them up. That's not what the law says. But it's a different process. It's a different way of handling things. But I can't imagine, as I was sitting here listening to Ms. Merriweather, immediately, of course, my elderly neighbor came immediately to my mind. And I just was thinking, what if he started trying to pull up that fence that's in between the property? What if he started tying his animals and came around to the other neighbor's yard and was tying his animals? Or what if he tied his animals right here at the part where we can both, sort of enter and exit our property from this one area? And I was thinking, I would immediately try to get in touch with his children. And I would say, your dad, I don't know what's going on. Your dad is, showing me signs that maybe he's not completely there. Maybe there's because he's tearing up the fence and he's tying stuff to the fence, right? I really don't want to, have to get the police involved, but, have you all noticed anything about your dad? Like, I literally would contact his family. It would never dawn on me to spray him with water. It would never dawn on me to engage him physically. In fact, I would have to call his family to say, your dad was physical with me. And I had to just push him away to get away. Your dad was physical and I had to push him away to get away. I hope I didn't hurt him. This is the conversation I'm having with his family if that was to happen. To my, no ma'am, it's my turn. It's my turn. I don't want to hear anything else you have to say. That's what I would do with the elderly person that might be clearly exhibiting some signs of mental illness, of dementia, of all of those things. People exhibiting signs of dementia are aggressive. And what they don't need are people under 60 beating them up. What they don't need are people under 60 coming at them with a broom. What they don't need is people start two sisters. And I understand the other person is a defendant. She has not pled guilty. She's not been found guilty. But what they don't need are people attacking them because they're doing things that clearly might be showing that there is some level of mental illness involved. Now, what the charge should have also been is elder abuse. I don't work in the prosecutor's office. As I'm listening, I'm thinking, why did they even negotiate down to this? That's what I'm thinking. When I'm listening, some stuff shouldn't be negotiated. I was watching some case, and the judge asked the prosecutor, are there any offers? The prosecutor said, no, we're not making any offers. We're not reducing this. This got to go to trial. Because there are a group of people that need protection. Those are elderly people, those are mentally ill people, and those are kids. They need protection. So coming in here saying I've never been in trouble, it got out of hand, that says a lot about the person that you really are. And every person has to take an introspective look at what type of person am I really? Because it doesn't matter what type of person you are when the going is going good, when nobody is bothering you. It doesn't matter what type of person you are when a person who when your neighbor is a beautiful neighbor. It doesn't matter what type of person you are, but when your neighbor is not the nicest neighbor, when your neighbor may be exhibiting some signs of some type of mental illness, distress, or just downright mean. If your neighbor is just downright mean and they're a senior citizen, just stay in your house. Call the police, get a camera. Let the family know, listen, I don't want to have to put your mother in jail. But if she keep doing this stuff right here that's on my camera, I'm going to have to put her in jail because I want the quiet enjoyment of my property. But what we don't do is beat up the people. I remember my mother living in a place, and my mother is hard of hearing, real hard of hearing. That's why I talk so loud. That's why I don't care what people say about how I talk. I don't care. I could care less. They don't know my story. My mother is hard of hearing. She never wore hearing aids until way, way later. So we always talk loud because she needed to be able to hear us. And she wasn't going to admit it was her. So we got to talk loud. And then she moved into a place and she plays her TV so loud because she couldn't hear. And her neighbor upstairs, I don't know if he thought she was doing it on purpose or not, but he started in the middle of the night to get back at her, banging on his floor with something, banging on his floor. And so me and one of my big nephews, we had to go upstairs and let the man know, listen, you know, she's hard of hearing. She's not doing it on purpose. And if you keep banging on that floor, it's going to be a different type of situation. So stop banging on that floor. We're going to work with her to get the TV lower. We're going to try to see if we could get her hearing aid adjusted, but you're not going to keep banging on this floor, scaring our mother and our grandmother. You're not going to keep doing that. That's somebody's mother, sister, auntie, something. That's wrong on every level. This situation is wrong on every level. Every level. Now, I am glad it does appear, I do believe that Ms. Merriweather has remorse. She sounded sincere to me. But then, even after she sounded sincere to me, it sounded like she went right back to justifying her actions and behavior. I mean, an old person would almost just have to be beating me with getting ready to beat me with a pipe or pulling out a gun on me in order for me to attack a older person. I would really have to feel like my life is in danger. And if I went outside and saw my sister beating up the older person, I'm not going to attack the person. I'm going to grab my sister and say, what the heck is going on here? What are you doing? I don't know if Miss Griffin was in the wrong. I don't know if she tore up your fence. I don't know. But if she tore up your fence, there's a civil remedy for that. If she tore up your fence, then we get, oh, it's snowing. Then we get cameras. If she tore up your fence, if she putting her animals on the fence and the animals are in distress, call animal control. Call the Humane Society. Call somebody. These dogs, these animals, y'all come save the dogs. Come save the animals. Right? Okay. So I've said my piece, but this is horrible. Let me just say that to you. This is horrible. The court is going to impose the following sentence. Ms. Griffin, she asked me to impose the maximum extent of the law. I'm not going to. This is your first offense. I'm not going to put you in jail, but I can guarantee you this: you don't have room to not do this probation. Probation is the alternative to jail. Jail is the alternative to probation. Probation is the alternative to jail. Jail is the alternative to probation. I do have one slight problem with the offer, but I'm gonna all right. The people's offer was 771 if eligible. They had no objection. Probation, even though they put eligible for 771, they recommended 15 months probation. The court is going to do the following. I am going to okay. So the statute indicates that the court cannot delay sentence longer than 12 months. This is what I'm going to do. I'm going to accept the recommendation from probation for a 15-month probationary period. However, I'm going to set the matter for review at the halfway point for the 15 months. So that means she wouldn't be eligible for early discharge until 7.5 months. Then if she doesn't make the 7.5 months, we'll set a probation review. If she completes the probation within the 12-month period that the law says that the court can delay the sentence, then I'll give her the delayed sentence. If she doesn't complete it in the 12 months, then she doesn't get the delayed sentence. So it's kind of a delayed sentence. So we're going to say delayed if completed within 12 months, but the probationary period is 15 months. And then So that will put a final review date for May the 15th of 2025. And I'm gonna set an interim review for, I'm gonna actually set a review in July. So we can see where she is, how she's doing. July 3rd. Strike it, July 3rd, July 3rd at 10 o'clock. The following terms and conditions: you shall not violate any criminal law of any governmental unit. You must not leave the state without permission of the court. You must make a truthful report to probation on a monthly basis and notify probation immediately of any change of your address, phone number, or employment status. You will pay $210 mandatory cost, a $100 attorney's fee, a $400 fine, no restitution, supervision fees at a rate of $35 per month. For the 15 months, it's $525. Of course, it will be prorated depending on when she gets discharged. A $50 pre-sentence investigation fee. You shall not use or possess any illegal substances, no marijuana without a valid medical marijuana card, no opiates without a valid prescription, no driving without a valid driver's license. Absolutely no contact with the complaining witness. Ms. Griffin, that means you can't go on their property, ma'am. You cannot go on their property. "15 weeks of anger management." I'm sorry, 24 weeks, excuse me. "24 weeks of anger management." I was debating with respect to the mental health evaluation, and I'm not gonna order it just at this time. I'm not gonna order it. I am going to order random urinalysis for the first 3 months, so I'm gonna add $30 to the court costs and fees, and if the if there are no positive tests, then probation can on its own stop the testing. She doesn't have to test after 3 months if there are no positive tests. Pay any outstanding tickets with 36th District Court. According to the report, you have none. Clear up any warrants. According to the report, you have none. And the total fines, costs, and fees are $1,315. Of that $1,315, oh wait, did I add the 30? Hold on, I'm sorry. Yes, of that, $1,050 and I'm sorry, $1,053 would need to be paid at that by the halfway point to get discharged. And again, if she finishes within the 12 months, then the court will delay the sentence and dismiss the matter off of her record. We will mail a copy of this order to the Devonshire address, and probation will contact you at the phone number ending in 7701. Anything further?
Judge, thank you.
Nothing on behalf of Ms. Meriwether. Thank you very much, Your Honor.
Oh, wait a minute. Hold on. Why I can't hear you? But because I had the whole thing on mute. I'm glad y'all wasn't trying to say nothing to me. All right, Ms. Stevenson, anything further?
Nothing on behalf of Ms. Meriwether. Thank you very much, Your Honor.
Ms. Ritter?
Nothing from the people, Judge, thank you.
All right, then we're all set. Have a great day and stay safe.
Okay, thank you.
You're welcome. With respect to Ms. Griffin, you're all set, ma'am.
Thank you, y'all.
You're welcome. I don't see Rivers in the waiting room. Is Rivers in? It's probably that iPhone.
Rivers is in breakout, Your Honor. I needed to talk with her very, very briefly.
Oh, can you? Because
yes.
Okay. Miss Hall,
Yes, Your Honor.
what are you ready on?
I am ready on McCullum, Hardwick, Jones, and Cohen.
Miss Ritter, did you go on a break?
No, Judge, I'm right here.
Mr. McCullum, please start your camera. All right, Mr. McCullum isn't ready. We're going to move on to Hardwick. Mr. Hardwick not ready either. We're going to move on to who else did you say?
Jones and Cohen. Their reviews.
Oh. All right, let's go with Cohen and then Jones. Do y'all have windows where you are? Do you have a window? What's going on? I didn't check the weather.
Yeah, it's supposed to be like this the whole night.
Okay. Oh, please. Okay. Well, I didn't. That's appropriate for that. All right, this is case number 204410601. The people versus Jared Peter Cohn. The defendant is charged with malicious destruction of property. Today is the date set for review. Appearances, please.
For the record, Your Honor, Rakedia Hall on behalf of Jared Cohen. Sir, may you unmute yourself and state your full name for the record.
My name is Jared Peter Cohen.
Today is the date set for review. And Mr. Cohen was placed on probation for 9 months back in August of last year. And he has done everything except it looks like he needs to complete the anger management. He started for 5 more. Oh, he's only done 1 anger management. So he needs at least 5 more weeks.
That is correct, Your Honor. And I did want to state for the record that Mr. Cohen, the reason why he indicated he started later was because he wanted to take care of the costs and fines, which he has done. So it's not that he was just waiting to start, but yes, Your Honor, at least 5 more weeks.
So August. But that'll be the end of his probation. Is he already on the docket, Mr. Flanagan, for some date in May?
Yes, Your Honor, May 2nd at 10 a.m.
And see, this is why I don't like when it takes long for Miss Ritter, what's the name of your complaining witness on Rivers? They've been in the waiting room all this time and now they're not there.
Ms. Moore, she keeps coming in and out.
Okay. Well, let's bring her on in. All right, May what, Mr. Flanagan?
May 2nd at 10 a.m.
Let's make sure that's a good day. It is. All right. So we're going to just continue, Mr. Cohen, to the final review of May 2nd at 10 o'clock a.m. Anything further?
No, Your
Anything
Honor.
further for Mr. Cohen, Your Honor?
All right. We're all set then, Mr. Cohen. Have a great day. Stay safe. Okay.
Thank you very much, ma'am.
You're welcome.
You too.
Thank you.
Bye-bye.
I'm ready on. Oh, wait. What happened to her? Oh, I said bring her in. No, he doesn't. No, he doesn't. Well, he's not going to be able to attend the hearing then. Retain counsel and you can't. I'm ready on Rivers. This is case number 224449201, the People versus Latoya Deshawn Rivers. Defendant is, I added Deshawn, but it may just be Daisha. Rivers, defendant is charged with one count of assault or assault and battery. Today is the date set for final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people, the complainant witness is present via Zoom this morning. Ms. Moore, unmute yourself and state your name for the court, please.
Hallie Moore.
Today is the date set for final I apologize. On behalf of the defense, I'm sorry.
Janice Stevenson on behalf of Ms. Latoya Rivers. Ms. Rivers, ma'am, please unmute and say your full name.
Ms. Rivers, please unmute.
Latoya Rivers.
And say your full name.
Latoya Deshae Rivers.
Today is the date set for final pretrial conference. How are we proceeding?
Thank you, Your Honor. Ms. Rivers continues her plea of not guilty and continues her jury demand.
The court continues a not guilty plea on behalf of Ms. Rivers. Set the matter for jury trial. Mr. Flanagan, September 23rd. Is that? I only have one listed.
Yes, Your Honor, just one.
When is the final pretrial conference?
August 23rd.
All right. I need Ms. Moore to be stationary. Court is going to set the matter for jury trial September the 23rd. At 10:30 a.m. with the final pretrial conference, August the 23rd at 9:10 a.m. Bond will continue with no contact between the parties. Anything further?
Oh, thank you, Your Honor.
Nothing on behalf of Ms. Rivers. Thank you, Your Honor.
All right, then, ladies, we're all set until, well, Ms. Moore, you're all set until September 23rd. You may appear at the final pretrial conference, August 23rd, if you want to, but you're not required to. And then the jury trial is September 23rd. Anything further?
Thank you, Judge.
All right, we're all set, ladies. Have a great day. Stay safe.
Thank you, Your Honor.
You're welcome. Ms. Stevenson, I mean, your client, Mr. Collins, has been sitting in the room all day. I brought him in twice. But,
Yeah, I'm not sure, Your Honor. I spoke with Mr. Collins and advised him that he has court tomorrow.
all right.
Your call cannot be completed if not.
Mr. Flanagan. All right, this is McCullum, case number 02-584-8501. The people of the state of Michigan versus Andre, middle initial C, McCullum. Defendant is charged with assault aggravated. Today is the date set for pretrial pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Rakidia Hall on behalf of Andre McCullum. Sir, may you state your full name for the record?
Andre McCollum.
Today is the date set for pretrial conference. How are we proceeding?
Your Honor, we are requesting a dismissal in the absence of the complainant. If the court is not inclined to dismiss this matter, we have no objection to an adjourned pretrial requiring the complainant to appear.
Ms. Ritter, on behalf of the people on this 2002 case.
Your Honor, I don't see the complainant witness, Mr. Stefan Naylor. However, it is from 2002. I respectfully ask the court to adjourn this pretrial conference and give the people an opportunity to try to locate this complainant witness and see how we will move forward in this matter.
2002.
Yes, Your Honor. We still have the contact information. We just want to reach out to see if we can make contact.
No, that's old. They moved in 21, 2 years. We don't know. Let's see. Look, one of the people that watched said Ms. Ritter will try to raise the dead for these cases. You better keep on being a great prosecutor. Can the iPhone please unmute and state your name? Not you, Mr. McCullum. Can the iPhone please unmute and state your name?
Rashad Pack.
Oh, okay, Mr. Pack. I think they already talked to you, Mr. Pack. Did you all already talk to Mr. Pack? Okay. Mr. Pack, hold tight. I want to go ahead and actually do Mr. Pack as soon as possible. But let's Mr. Pack, are you still where you were earlier today?
No, ma'am.
Okay. I mean, okay. Just give us a moment, Mr. Pack, then.
Yes, ma'am.
All right, with respect to Mr. McCollum, the people want an opportunity to locate the witness and see if they still want to proceed in the case. Court is going to deny defense counsel's motion for dismissal, grant the people's request for an adjournment so that they can try to locate this complaining witness from 20 years ago. And court is going to set the matter for April 2nd. At 8:36, the complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complainant could not appear or should not be required to appear. Bond will continue with no contact with the complaining witness. Anything further?
Thank you, Your Honor. Thank you.
Nothing for Mr. McCollum.
All right, Mr. McCollum, you're all set until April 2nd. Have a great day. Stay safe.
Thank you.
You're welcome. All right, Mr. Pack, can you turn on your camera? Oh, you can't. Hold on. Let me change the settings. I'm sorry, Mr. Pack. All right, turn on your camera, Mr. Pack. All right. Okay, this is case number 440-2102. I think this is my first 24 case. Oh, Hardwick is. People of the state of Michigan versus Rashad Parrish Pack. Defendant is charged with 1 count of retail fraud. Today is the date set for an arraignment. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Rashad Pack. Mr. Pack, good morning to you again, sir. Please unmute and just say your full name.
Rashad Parrish Pack.
Thank you, Mr. Pack. Today is the date set for an arraignment, Ms. Stevenson.
Mr. Pack stands me waives the reading of the information as to the plea of not guilty be entered on his behalf, that the matter be set for a pretrial conference, and that Mr. Pack be released on personal bond, no objection and no contact with the complainant, Your Honor.
Court enters a not guilty plea. On behalf of Mr. Pack, set the matter for pretrial conference. Mr. Pack, with respect to where you were earlier today, what days does that occur?
I have dialysis on Tuesday, Thursday, and Saturday, from 5:30 to 9:30 in the morning.
Okay, so it'll be better to do it on a Monday or Wednesday for you?
Yes, ma'am.
Okay, so let's do pretrial conference. How many do I have on Monday, April 8th, Mr. Flanagan?
Seven.
Actually, how many do I have on April 15th? I have a lot. I think April 15th, I put a lot on there. And those jury trials. How many do I have on April 15th?
6.
Oh, I didn't put a lot. Okay. Let me see if I could give him an earlier date. We're in February. And then March. What about April 3rd? I have 16.
Yep. Yes, ma'am.
Let's put Mr. Pack on April 3rd. At 8:25. $500 personal bond, no contact with the complaining witness. Who is the complaining witness?
Save a lot, Your Honor. Oh, I'm sorry, Ms. Ritter.
That's correct.
Save a lot. No contact with Save a Lot.
Yes, ma'am.
All right, we're all set unless there's something else for the record.
No, thank you, Your Honor.
Nothing on behalf of Mr. Pack. Thank you very much, Honor. Thank you for allowing Mr. Pack to come on in later in the morning. He appreciates that.
Oh, yeah, no problem. And then you have to remind me next time too, if we have to go at another date. Remind me Mondays and Wednesdays.
Yes, Your Honor.
All right, you're all set, Mr. Pack. Have a great day. Stay safe.
And there's, just for the, you said April the 3rd at 8:25.
Yes, sir.
Thank you, ma'am.
All right, you're welcome. Okay. I feel like this is a lot of cases. Okay. I have some people highlighted that are not here. Oh, Jones is in the. Oh no, that's a different Jones. Oh, there's Jones. Okay. All right. I'm ready on, I guess, Dinkins. This is case number 235767501. The People versus Charles Dinkins. Defendant is charged with violation of the Medical Marijuana Act, and it's on the docket for a review, but Mr. Dinkins has not been sentenced. My review of the register of action, unless somebody has something different. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people. It does, the charges I have on the docket is possession of a motor vehicle, maybe unlawful possession of.
Is that what that means? That look like the same initials when it's marijuana. How I'm supposed to know when MT don't stand for Marijuana Act? Okay, possession of a motor vehicle. Okay, I see it now. Somebody gonna have to do something. Okay. I'm looking at the register. Motor vehicle possession of the master key. Okay. All right. Appearances, please.
Rakidia Hall on behalf of Charles Dinkins II. Sir, may you state your full name for the record?
Charles Wayne Dinkins II, Your Honor.
All right. Thank you. Today's the date set for, it says review. However, a review of the register of action indicates that Mr. Dinkins was scheduled for sentencing on November the 3rd. And on November the 3rd, he was not brought over from the jail. It says the jail called. Well, strike that. He was scheduled for sentencing for September the 20th. And then we had him down for failing to appear. The jail called and he wasn't brought over. And then he was scheduled on November the 3rd. And then on November the 3rd, he failed to appear. And I don't know if he was still in custody because he's still in custody right now. And then he was arraigned by the magistrate and scheduled for this date. So, Ms. Hall, he's never been sentenced.
Your Honor, we are asking for a sentence of 90 days in jail, credit for time served. I have spoken with the deputy and it looks like he has been in custody from August 24th to October 3rd, and then again from October 25th till now.
On this case or something else?
Other cases.
Okay. Miss Ritter, who is the problem with me doing that today is, I don't know, did the victim show up before to give a victim impact statement?
Your Honor, so I just had to pull up the register of action. So it looks like it started off as a felony and the convict was reduced to receiving concealment. No, I'm sorry, possession of master key motor vehicle. And the court is correct. The defendant was never sentenced. However, there is a complaining witness on this case. So I'm actually going to ask the court not to proceed to an immediate sentence only because it looks like there's some restitution that may be imposed on this case.
Well, this is what I'm gonna do. I will. Deputy, is it,
Yes, Your Honor.
do you know Mr. Dinkins' next court date on his other case?
It is March 5th.
March
Your
5th?
Honor.
Okay, thank you. Let's schedule him for March, hold on. Let's schedule his sentencing for March 4th. That gives the people an opportunity to contact the complaining witness to see if they want to come and give a victim impact statement. I know that's like what's today? That's
The 15th.
1, 2. That's like 3 weeks. Is that enough time for the people?
Yes, Your Honor, that should be enough time for us to contact the complaining witness.
All right, let's schedule the sentencing for March 4th. Because am I doing that on the same day? Y'all, this snow is distracting me. Okay. What day was his next court date on the other case? March 5th, right?
5th.
Okay, yeah.
It's March 5th before Judge Deborah Thomas. This case came to light based on what she wanted to do with her cases.
Okay, so yeah, let's get him in here the day before he goes back to Judge Thomas. March 4th, 9 o'clock, and the people can contact the witness, see if they want to make a statement. All right, we're all set, Mr. Dinkins.
Thank you, Your Honor.
Thank you, Your Honor.
All right, you're welcome. All right, I'm ready on Walker. Mr. Flanagan, nobody ever came on Jones debates, and Mr. Jones is not here anymore.
No, Your Honor. I got no word from their office, and it looks like Mr. Jones is in a breakout room, number 5.
Oh. Well, who in there talking to him? Oh, that's Miss Stevenson.
I can't even hear it.
Menace. Just a mess. Ms. Hall, go tell your colleague she doesn't need to talk to Mr. Jones.
Okay, Your Honor.
In fact, don't it? Oh yeah, no, it's another person in there. Hughes. Yeah, she don't need to talk to Jones. I'm gonna move him out while she talking to him. Mr. Jones. Mr. Jones. He's not connected. Okay. All right, when he connects, then I'll jump back to Mr. Jones, but I'm ready on Walker. This is case number 234-572301, the people of the state of Michigan versus Aaron LaKenya Walker. The defendant is charged with brandishing a weapon. Today is the day set for pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Erin Walker. Ms. Walker, ma'am, please unmute and say your full name.
Ma'am, stop, ma'am. Unmute and say your name. Ms. Stevenson, your client can't hear us. Mr. Jones, can you turn on your camera, Mr. Jones?
Okay. My thing is saying low
Low battery?
no, not low battery, low connection.
Oh, okay.
Okay.
Mr.
Okay,
Jones,
yeah.
Mr. Jones, I had received some information earlier from your lawyer that she was sick and not able to come, but she was trying to get someone to appear for her.
Yes.
Apparently that did not happen. So
Yes.
we're going to contact her office and then we'll have to give you another date. Okay.
Mhm.
All right. So, Mr. Jones, can you take down my courtroom phone number and call
Yes,
my
ma'am.
courtroom so we can make sure we have your phone number so that we can call you with the new date?
Yes.
Okay. Call 313
Mm-hmm.
965
Mm-hmm.
2295.
Okay.
All right, call there and then give my clerk your phone number. So when we get the new date, he can call you and let you know, okay?
Okay.
All right, thank you for your patience today.
So am I done?
Yes, I'm gonna remove you, okay?
Okay.
But don't forget to call the courtroom,
I'm
okay?
gonna call right now.
Okay, good, thank you.
Mhm.
All right. Now let's try again with Miss Walker. She can't hear us. She not even, I don't know. And I'm getting ready to go into my motion hearing. So I'm getting ready to remove her because all of this laughing and talking she doing on here and not hearing us. That's a mess. That's a mess.
There it is.
Yeah, okay. So do I need to call the case again? I was getting ready to remove her. Right, she can't hear me and I'm not getting ready to do that. Do you want her to go back in the breakout room? So because did she hear you when you was in the breakout room?
So, I already reviewed this with Ms. Walker. I don't remember whether, okay, I don't know if we ever had good connection with her this morning. I don't remember, Judge.
Well, you don't have good connection now, and I'm getting ready to, yeah, okay.
I unmuted, but I can't hear it. Hold on.
Could she please return to breakout? So that we
Yeah.
could- Thank you,
Yeah,
Your
because
Honor.
that's disruptive, okay. I'm ready on Kendall Jones. And then I'll find out who the iPhone is. I'm sure it's somebody that's already been here. All right, this is case number 204552701, the people of the state of Michigan versus Kendall Martez Jones. Defendant is charged with assault or assault and battery. Today is the day set for review. Ms. Hall, your appearance, please.
Rakidia Hall on behalf of Kendall Jones. May you unmute yourself and state your full name for the record?
Good morning, Kendall Martez Jones.
Thank you, sir. Today is the day set for review. Mr. Jones was placed on probation 12 months ago. His probation is scheduled to end today. Well, it says tomorrow. And he still has one anger management class. Oh, I remember Ms. Jones. I remember him. Okay. Okay, so he's scheduled to be off today, but he still has the one class left. When is that scheduled for?
On Tuesday, the 20th.
All right, then let's just adjourn him for Yeah, my mind is not going, I need to let down my. Mr. Jones, did you know, are you in Michigan?
Yes, I am.
Did you know it was gonna snow today like this?
When I got off work this morning, it started to snow.
Oh, this is too much for my whole self to bear. Okay. Let's come back next Thursday. And then if you all somebody need to do is bring to my attention that you finished the class, I'll discharge you, okay?
Okay, thank you.
You're welcome. All right, so we'll adjourn 1 week. And that is February 22nd. All right. Don't let us hold you all day. You know, remind us that you just had to do that class, so I could go ahead and let you go, okay?
Okay.
All right, have a good day. Stay safe.
You as well.
Thank you. Can the person on the iPhone unmute and state your name? And state your name.
Can you hear me?
Yes.
Okay, good morning, Your Honor. This is Marsden Ross speaking.
This is who?
Marsden Ross.
Well, where were you this morning, Mr. Ross?
Your Honor, I just opened up a restaurant and I didn't close until 4 o'clock this morning. I literally overslept and I apologize.
Mr. Flanagan, can you see if we could find the Assistant Attorney General?
Yes, Your Honor.
Mr. Ross, that's not going to be a good excuse.
I know.
Ms. Farage?
Yes, Your Honor.
All right, your client is Ms. Farage, and look, you just came from outside too, because Ms. Farage, did you know it was gonna snow like this? Because I did not.
No, I can't even see anything, Your Honor.
I am not prepared for this. I would not have come down here.
Oh, yeah.
I'm
I'm
not
sorry. I'm
prepared.
covered in snow. I'm sorry.
That's all you look. I'm looking out the window and I'm seeing this. Oh my goodness, I wasn't prepared. The shoes on my feet will tell everybody that I was not prepared. Okay.
Oh, no.
This is your client, Mr. Farage. He's here. If he could
Mr.
start
Ross,
the video, but I'm trying to bring back the assistant attorney. Oh, Mr. Farage, you gotta get out the bed.
Mr. Ross.
Oh,
Mr. Ross.
I mean, Mr. Ross. Oh, okay, that threw me out. Sorry, counsel.
It's okay. It's okay.
She like, no, Mr. Ross. Okay.
It's been one of those mornings. Maybe it's the snow.
Maybe. Let me disable his camera and tell him to get out that bed. Oh my goodness. Did you need to speak with him before Mr. Hayes comes back?
No, Your Honor. I think it's pretty straightforward. We just need the discovery and just the next court date if an offer is being made. That's about it.
So I'll put you back in the waiting room. Mr. Hayes is going to be logging in shortly. My clerk just messaged me. And then we're going to give Mr. Ross an opportunity to get out of the bed, put on some clothes, and come to court appropriately. All right. We'll give him
Thank you, Your Honor.
You're welcome. You're welcome. All right. All right. I have a motion hearing I got to attend to. So I'm ready on Walker, and then I'm ready on my motion, I suppose. Do I have anybody else left in the breakout room?
I have one that I need some help with from the people.
Okay, well. Can your client hear us now?
Yes, she was able to hear me in the breakout room, Your Honor.
All right, we're back on the record with case number 234572301, Aaron LaKenya Walker. And we were at the point of asking Ms. Walker for her name.
Please unmute Ms. Walker.
It's Aaron LaKenya Walker.
Today is the date set for pretrial conference. How are we proceeding?
Thank you, Your Honor. Ms. Walker continues her plea of not guilty. We would ask, well, actually, we'd move for dismissal, Your Honor. If that motion is denied, we'd ask the matter be set for final pretrial conference and would request discovery.
The motion is denied, but Ms. Ritter, with respect to my denial of the motion, what is the people's proofs with respect to the brandishing? Is it an individual or is it the police?
So it looks like the complaining witnesses are civilian complaining witnesses.
All right. The court is going to deny the motion to dismiss, and I will adjourn the matter, giving the complaining witnesses an opportunity to appear. Give me 1 second. Court is going to set the matter to April the 4th at 8:36. The complaining witnesses are required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the witness should not be required to appear or could not appear. Bond will continue. Anything further?
Sorry, Judge, may I have that date again?
April 4th.
Thank you, Your Honor. Nothing further from the people.
Nothing on behalf of Ms. Walker. Thank you, Your Honor.
All right, Ms. Walker, then you're all set until April the 4th at 8:36. Have a great day. Stay safe.
Thank you, you too.
Thank you. Mr. Flanagan,
Yes, Your Honor.
is, Mr. Marks isn't on the jail list, is he?
Marks? No.
Yeah, I didn't think so. Okay, well, I'm coming downstairs. Oh, wait, here come Mr. I'm coming downstairs. I guess Miss Ritter gonna be on Zoom for the hearing.
Okay.
I'm sorry, Judge, I noticed that, I think I saw defense counsel in person. Was this an in-person hearing?
No, I didn't say it was.
Oh, okay. I was just making sure.
No, and the meeting I came down here for, they just canceled it.
Okay.
Now I gotta go in the snow, you see. All right.
Madam Prosecutor, I need your
She
help.
needs you. So while we do this case, Miss Ritter, go do that. And I'm going downstairs. And you're gonna be the only one on Zoom for the motion.
Okay.
Have a nice day, everyone.
Oh, whatever, Miss Hall. No. Bye, Miss Hall. All right, Miss Farage, I think we're ready. All right. Oh, now Miss Farage is driving. Miss
I'm
Farage.
pulling over, Your Honor.
Yes, pull over.
Please be careful in that snow.
Because I would sure hate for them to try to call us a witness if they pull you over and say distracted driving. Then me, Mr. Hayes, Mr. Ross, we all have to come in. I'm not gonna answer. All right.
Okay, I'm good now.
I'm gonna be like, I didn't see her. I couldn't see on the Zoom. Okay. All right. This is case number 234427201. The People versus Marsden Edward Ross. Defendant is charged with 1 count of trespass, and today is the date set for pretrial conference. Appearances, please.
Good morning, Your Honor. Robert Hayes, Assistant Attorney General, here for the people,
Mr. Ross,
P690016.
adjust your camera. We're looking at your chest and your bottom lip. Okay, there you go. Sorry, Mr. Hayes.
Robert Hayes, Assistant Attorney General, here for the people.
Good morning, Your Honor. Attorney Sahar Faraj appearing on behalf of Mr. Marsden Ross, who appears via Zoom. Mr. Ross, can you please state your name for the record?
Good morning, Your Honor. Marsden Ross.
I feel like you still laying down, Mr. Ross.
No, ma'am, I am not.
Okay.
No,
All
ma'am.
right. Today is the date set for pretrial conference, Ms. Faraj.
Your Honor, at this point in time, we have yet to receive any discovery related to the matter. So we're just asking that both the police report and any digital discovery and any other discovery that is in possession of the prosecution be sent over.
All right, the court will continue a not guilty plea on behalf of Mr. Ross. I will set the matter for a final pretrial conference. Is April 17th okay with the discovery date of March 18th? Is that good is that enough time for the people?
Yes, absolutely, Your Honor.
Okay, so is that a good date for defense?
April 16th, Your Honor?
17th, April 17th.
Yeah, I should check that should be okay with defense. Yes.
Okay, so I'm gonna set the matter for April 17th for final pretrial conference at 9:00 a.m. And then discovery will be submitted to the defense by March 18th. Bond will continue. Which casino is this, Mr. Hayes? Is he banned from all 3 or just 1?
Your Honor, I believe Mr. Ross has been banned from all of the casinos in the Detroit area.
All right, then no contact with any Detroit casino. All right, anything further?
Not from people, Your Honor. Thank you.
Nothing further from defense, Your Honor.
All right, we're all set. Have a great day. Stay safe.
Thank you, Your Honor.
Thank you.
You're welcome. Thank you for coming back, Mr. Hayes.
Of course.
All right. All right, I'm coming downstairs. Oh, yeah. See me. Or you can zoom it out kind of so we can see me and.
Oh, okay.
And. Yeah. You can be like Ms. Moore, but she never. All right, I'm ready. This is case number. I'm reading from this motion, so I don't know if this is correct, but this is case number 234478001, the people of the state of Michigan versus Alexandro Pacheco, defendant is charged with, I think it's brandishing. I didn't bring it down here. What's the official term? Oh, assault or assault and battery. And today is the day set for, hearing with respect to defense motion to suppress. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people, P number 83505. And Judge, I understand that everybody's in the courtroom, so if the court can't hear me, I will just try to put my headphones in just to keep my voice up so that the court and the court reporter can hear me.
No, we can hear you.
Yes.
Real well.
Okay.
Mr. Flanagan must have turned it up. I don't know. All right.
Eric Clark, P31126, appearing on behalf of Mr. Pacheco, who stands to my left.
And your P number?
31126.
And then your name?
Alejandro Pacheco Rosario.
Thank you. And then just so you know, counsel, the court reporter is here. She's on Zoom.
Okay.
You just can't see her because she's off camera, but she's on Zoom. All right, so today they set for hearing with respect to Mr. Pacheco, you can have a seat.
Okay.
With respect to the defense motion to suppress. I have read the motion. I have read the people's response. I'm gonna let you make argument, but I am gonna tell you, counsel, so I know I said that I would let you all know if I was gonna set a evidentiary hearing. So I was thinking, I was waiting to see if you were gonna file a reply. And here's why. So when you make your argument, I'm gonna tell you that the reason I have not set an evidentiary hearing is because of the people's response on page 2 and their reference to people be tyranny. And yes.
Did you say people be tyranny?
Tyranny, TIERNEY, 266 Mishap 687. And then at page 703, that's her site, and then 2005 case. And that talks about the lack of reasonable expectation of privacy on a porch. And so I wanted to hear your response to that, because so just in making your argument, and if you have a response to that,
I'll make that argument up front.
Okay.
Before I do the rest.
Okay.
I have cited the state of Florida versus Jardius, which is a 2013 case, which was decided by the U.S. Supreme Court, which held that the front porch of a home is in fact part of the home itself for Fourth Amendment purposes. As a result, there is a higher expectation of privacy when you go to search a home, and the porch is part of the home. So this is a Supreme Court case and a 2013 case, not a 2005. So
and I'm going to do some apologize because you know what, I haven't highlighted, but for some reason I said when I signed up Florida case, I literally did, but it's a U.S. Supreme Court case.
correct. So it takes precedent over the state case.
Okay.
But in any event, Judge, I have no objection to the court setting an evidentiary hearing. And the reason I say that is Ms. Ritter, during discovery, has provided me with a body camera video that shows the entire event from the moment the police pull up to their various searches, to the arrest of my client, from start to finish. What it shows is that, based on a radio run, they come to his home, which is a fourplex. He lives on the bottom apartment, and each apartment has their own porch. When they arrive, my client is simply sitting on the porch, doing nothing, sitting on the porch. They approach him immediately, apparently based on the identification from the complainant, and simply ask him to stand up. They arrest him, they put him in handcuffs, they search him with negative results, and then place him in the patrol car, which is on the other side of the street down a few houses, and secure him and detain him there. They then come back and talk to the alleged victim, who tells the police that my client was seen by his truck, with a gun. The truck is parked on the side of the house, not near the porch, or not, walk around.
And you're telling me this based on the body cam?
Yes.
Okay, yes, go ahead.
And they search the truck, don't find anything. The body cam then shows the police searching the front of the house, the grass, the landscape, the trees, again, nothing. A short time later, one of the officers then goes up on the porch. My client is a scrapper back then. I'm sure the court is familiar with it. So he has bags and stuff where he keeps on the porch. The video shows the officer kneeling down behind a number of bags and eventually pulling out a BB gun and saying, aha. It is our position that because there is no search warrant, that one was required to search his home, especially after he's secured and no danger to anybody. He's detained in a police car. There's no urgency, there's no extringent circumstances that exist to not get a search warrant for his home, plain and simple.
Ms. Ritter, what's your response? Because I agree with defense that Florida v. Jarvis would supersede People v. Tierney. People v. Tierney is 2005. Florida v. Jarvis is 2013, and it's a U.S. Supreme Court case. And it says that the search of the defendant's porch was unlawful since there was no exigent circumstances. Well, I'm sorry, without without permission or another license. That's what the police officers were conducting an unlawful search when they searched the person's porch. So what's your response to that?
Well, Judge, the people's response is that in the case that people cited on people's response page 2, as the court pointed out, People versus Tierney, that defendants did not have a reasonable expectation of privacy in the enclosed porch of his parents' home. That's cited from the case law that was provided by the people. And the police officers could.
That case predates the Supreme Court saying a person does have a right to privacy on their porch.
Understood, Judge. So the case that was cited on page 2 talks about the officers going into a common area where visitors are expected to go, i.e. the walkways, the driveways, and the porches. I think that the people pointed that out because, like Mr. Clark stated, the defendant lives in a multi-family duplex, I would say, and the complainant witness lives on the top unit. So it's a duplex where there are units on the bottom and then units on the top. So the people added that in their response because that porch will be considered a common place where visitors will go. And in response to Mr. Clark's motion, the US Florida case that was cited states that the search of the defendant's porch was unlawful, especially since no exigent circumstances existed. So going back to the facts of the case and just adding a little more detail according to the investigator's report, I'm sorry.
No, go ahead.
Oh, I'm sorry. So there was a 911 call placed by the complaining witness to dispatch that the defendant was seen with a handgun. So at that time, it wasn't known that it was a BB gun, but it mimicked a real handgun. So there was a 911 call placed by the complaining witness. Officers were dispatched to the location where they spoke with the complaining witness, and the complaining witness showed them the picture, the alleged picture of the defendant holding this handgun outside in the driveway. So the officers searched the defendant, Mr. Pacheco. They didn't find anything. They placed him in the back of the police car. And then the complaining witness told the officers where they last seen Mr. Pacheco with this handgun. So with that information, the officers searched that area, and that's where they found this handgun, now known to be a BB gun, in these trash bags on the porch. So if the court doesn't agree with People versus Tyranny, I asked the court to look at People versus Bouchelin, which was referenced in People's response on page 3. And in People versus Bouchelin, the court found that there were the court found that under the exigent circumstances exception, that the element of probable cause and reasonableness was determined that there was an emergency circumstance in that case. So comparing People versus Bouchelin to the instant case, Your Honor, I believe due to the 911 call from the complaining witness that there was a gun, that the defendant did have a gun, and that the officers came out, searched the defendant, and didn't find anything and detained the defendant, that the officers then searched the porch due to the 911 call, and that's when they discovered the handgun. So the court then held in that case, well, in People versus Bouchelin, Your Honor, the court mentioned the case, and I'm reading from the opinion, the full case. I didn't put the full case, Judge. I did put the citations for People versus Bouchelin in the People's response, but I'm reading from the full case. And in that case, the court mentioned United States versus Mexner, and I can give the citations that the court would like for that case. I have 2000 WL 1597736, Eastern District, Michigan, 2000. And in that case, Judge, there was similar facts to People versus Bouchelin. However, there is a contrast. So in United States versus Mexner, there was a 911 call placed. However, the caller hung up. There wasn't any information given to the 911 dispatch about any emergency, and the police were then dispatched to the home in that case. When the police got there, they knocked on the door. They didn't receive a response. At first, they didn't hear any sounds or any struggles or anything that would give rise to an emergency situation going on inside that home. Once they did get there, they came into contact with the defendant, who refused the officers to come into the home. And at that point, they detained the defendant and went into the home. So in that case, Judge, the people found that there actually was not an emergency circumstance that arise for the police to go into the home without a warrant. So using that case, Judge, like I said, comparing it to the instant case, in this case, there was actually an emergency due to the 911 call they received, and due to the safety of the public and the safety of the officers. The court, or the court in People versus Bouchelin, found that there was reasonableness and a probable cause to search that home and found whatever evidence they found in plain view. Now I'm asking the court to take into consideration People versus Bouchelin again, because I've noticed that defense counsel had that US Supreme Court case cited where they said unless there was an exigent circumstance, which in this case there is. So again, Judge, the people are asking the court to deny defense counsel's motion to suppress the evidence. And if the court is not inclined to do so, still have, after hearing the people's argument, the people are asking the court to set the evidentiary hearing for further consideration on the motion.
Well, I want to ask you, so the case that you just cited, and then at the sort of towards the end of your argument, you said that the court allowed the evidence that was found in plain sight. Let's talk about the plain sight. Mr. Clark in his argument says that if the court were to view the body cam, what I'm gonna find is that the gun was not in plain sight, that it was underneath some stuff, and they had to move stuff to get to this BB gun. So if it's not in plain sight, then how do they get it without a warrant?
Well, that goes to the people's argument for the emergency circumstance to search the area where the gun would be. So no, the gun was not in plain sight, Judge, but in that case, that's given an example of the officers going into the home to even start the search warrant and finding what they found in the home. So it's not in plain sight, but it does give the rise for the emergency circumstances for the officers to enter that area of the porch and find the gun.
Final thing before I allow Mr. Clark to have any rebuttal. So it would be the people's position that at the point that Mr. Pacheco is taken into custody, placed in the police car, that there still would exist an emergent circumstance?
Based on the 911 call that there was a weapon, Judge, and the officer did not find a weapon on Mr. Pacheco, yes, because at this point it's still a safety for the public and a safety for the officers to find the gun that was reported in the 911 call.
But couldn't they just have put Mr. Pacheco in the car and then come to the magistrate to get a warrant to search the porch while he's still in custody and while they still have eyes on the porch?
Well, that's not the people's position, Judge. In this instant case, like I said, there was a call from the complaining witness that there was a weapon on the scene. So at that point, when they didn't find the weapon on Mr. Pacheco, the police continued to search for the weapon to secure it and secure the safety again of the officers and the public at that instant time, Judge. So that's where I guess the level of the exigent circumstances arise because there were reports of a weapon.
Ms. Clark.
First of all, let me correct factual points you made. The porches on these units are independent of each other. There are no common porch. This porch belonged to my client, period, his apartment. So there is no commonality between the porches at all.
So is your position that Mr. Pacheco's neighbor
has no access to this porch?
And I'm talking about, when I say neighbor, so it's a fourplex. And then, so there will be two on the bottom, two units on the bottom and two on the top.
Yes. And each unit has their own porch. Now, as far as exigent circumstances, there is no emergency here. Once my client is immediately placed under arrest, handcuffed and placed in a car 100 yards away from the porch, he's no threat to anybody, public or the police. The fact that there was a 911 call in and of itself doesn't create an emergency. In fact, if you looked at the video, the incident took place over a half-hour period between the time they roll up, arrest my client, search the truck, search the front lawn area, and then finally search the porch. This takes time. There's nothing happening at all. The alleged victim is protected. The police are protected because my client's in the back of a car. There is no emergency. There is no extended circumstances. The Jardius versus the Florida State Florida versus Jardius prevails on the issue that you need a search warrant to search someone's house.
Okay. All right. So here's what I'm gonna do. I'm going to, one, read Jarvis in its entirety. I did not. Because two, even the other case, Ms. Ritter, that you cite, that seems like a 2000 case. The site that you gave is a Westlaw site. So there should be actually a permanent site, the 2000 WL 1597736 Eastern District 2000, that's a Westlaw site. By now, that should have a different site. That shouldn't be still citing from Westlaw. And then notwithstanding, that is still a 2000 case where the Jardius case is 2013, which would appear to be still the prevailing law. The second thing is, it does matter. So let me say this, it does matter whether the porch is independent. It does matter with court decision, whether the porches are independent porches or if the neighbor has access. Because if the neighbor has access, then he doesn't have an expectation of privacy there. So the court is going to set the evidentiary hearing. I thought I wasn't going to have to, but I am going to set it because I would need to see evidence of the porch to even determine if Mr. Pacheco, how do you pronounce his last name?
Pacheco.
Pacheco. Now I'll keep wanting to put another E in there. If Mr. Pacheco has a right to privacy, if he does have a right to privacy based upon the way the porches are made, or I shouldn't say a right to privacy, but an expectation of a higher expectation of privacy, because I can still look on a person's porch and see whatever I want to see. And there is nothing illegal about that. But then if the officers did in fact have to move things around, then that requires the court to find that the exigent circumstance existed at the time that they were moving these things around. Otherwise, it's an illegal search all day. I agree with the defense that a 911 call in and of itself does not create an exigent circumstance. But I want to now compare the cases, the two Supreme Court cases, but it sounds like Jardius is the one. Let's set up evidentiary hearing because I need to see the portraits. It seems like it's only necessary for one witness unless you all think different, but whatever officer had that body cam and did the search, are they the same officers?
I don't think so, because
okay.
the body cam lady was female and it was a male who searched.
Oh, well, they might
however, I would stipulate to the court just viewing the one body cam because it shows everything, even without the presence of a police officer. But
oh, okay, well, no, Ms. Ritter, you shaking
No,
your head.
I want my officers there to testify as to what happened when they arrived, so I'm not stipulating that.
All right, so let's set it for hearing. Let's put it on an afternoon. And let's do, are these, well, it's body cam, so it's Detroit police?
yes.
Yeah, okay. So today is the 15th. Are you available March 19th, council, in the afternoon?
19th?
Yes. No, I didn't mean it. I did not mean it. I'm looking dead at the date and saying a different date.
Okay.
Are you available March 13th?
Yes.
At 1:30?
Yes.
All right. So this is what I need you to do, Ms. Ritter. I'm gonna tentatively set the evidentiary hearing for March 13th at 1:30. But I need the people to make sure the officers are not on furlough. I don't wanna get here that day. And then we say the officers are on furlough. So today is the 15th. Can the people confirm by next Tuesday, the 20th, whether those officers are available for that hearing?
I can have that confirmed by tomorrow.
You always gotta go over and above and beyond. Okay, well, let us know tomorrow if the, if the officer, look, I'm trying to give her extra time. She wanted to.
No problem.
All right.
Judge, is there any special notice or something for the court to play a body cam video?
No, what you mean? What do you mean?
Well, I want the court to view the video.
Oh, absolutely. That's the whole purpose of the hearing.
Okay.
So the people will present the body cam video and then we'll view it. How long is it? Is it long?
No.
Okay. All right, but she's gonna let us know tomorrow if they are available that day. If not, my clerk is gonna call you for a different day.
Very
Okay, all right, anything further?
Yes, my client asked me if the court would consider removing his tether.
Yes.
He's had the tether on for 7 months.
Yes.
9 months.
Yes,
Excuse me.
it's removed. I'll remove it.
Thank you.
Judge, can we make sure there's a no contact order still with the complaining witness and the defendant?
We have a problem with that. He's moved and has no contact.
Oh, okay.
I'm still with my dad right now, and my stepmom.
Okay, well, yes, I'm gonna remove it. That's enough time to be on the tether.
Thank you, Judge.
Appreciate it. Thank you.
Plus, he has retained counsel. Counsel, give him one of those order things where he can write out the order.
For the tether?
Yes, removing the tether and no contact with complaining witness or the address. Since he's moved, no contact with complaining witness or the address. In person, 1:30, yes. In person, that's in person.
Yes.
That's in person. Ms. Stevenson? I'm ready on, Hughes, and then it looks like Ms. Williams is here on, did you need to, speak to Ms. Hughes, or we're gonna be good to go?
With Ms. Williams, Your Honor, I'm ready on both of those cases.
I read Ms. Williams.
Oh,
I'm still distracted by the snow outside, even though I'm downstairs in the courtroom, we can't see it anymore.
yeah, I'm very nervous because I don't see it, and so
Yeah,
I'm very nervous.
Okay, this is, this is case number. Ms. Hughes, turn your camera back on, please. All right, this is case number 224578301, the People versus Jasmine Hughes. Defendant is charged with 1 count of malicious destruction of property. Today is the date set. Today is the date set for final pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson, appearing on behalf of Jasmine Hughes. Ms. Hughes, ma'am, please tell the judge your full name.
Jasmine Hughes.
All right, Mr. Clark, hold on one second. Get a sealed order and give it to your client so he can go get the tether off now.
Thank you, Judge.
All right, today's the day set for final pretrial conference. How are we proceeding?
Ms. Hughes and I have had the opportunity to discuss this matter. She's had the opportunity to review with me an advice of rights form. It is my understanding that at this time, Ms. Hughes wishes to waive her rights incident to trial and offer the court a plea of guilty as charged to one count of malicious destruction of personal property, $200 to $1,000.
All right, Ms. Hughes, your lawyer indicates you want to enter a plea today. Is that what you want to do?
Yes.
I am going to share my screen. On the screen will appear a constitutional rights form. My question to you is, have you had an opportunity to review for yourself or to go over with your lawyer your constitutional rights?
Yes.
And when you did that, did you understand your constitutional rights?
Yes.
Do you understand that this is a misdemeanor and therefore you have a right to a trial? However, if I accept this plea from you today, you are giving up your right to a trial.
Yes.
Has anyone threatened you in any way or promised you anything other that was not placed on the record to get you to enter into this voluntary plea?
No.
Drawing your attention to number 8, are you currently on probation or parole?
No.
Finally, drawing your attention to number 11, do you understand that by entering into this voluntary plea, you may be giving up your right to an automatic appeal, and if you were to change your mind about the plea, you would either have to request permission of this court to set aside your plea or request permission of the circuit court to appeal the conviction.
Yes.
With that understanding, do you still want to give up your right to a trial and enter into this plea?
Yes.
Raise your right hand for me, please. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Stevenson.
Thank you. Ms. Hughes, on December 13th of 2022, were you present at 14583 Hubble in the city of Detroit?
Yes.
And there, did you willfully and maliciously destroy or injure the back car window, personal property of Sharquette Hadley?
Yes.
And was the value of that damage more than $200 but less than $1,000?
Yes.
Thank you. With that, Your Honor, defense is satisfied.
Are the people satisfied?
The people are satisfied, Judge.
Court is satisfied. I will accept the guilty plea to one count of malicious destruction of personal property. Having accepted that guilty plea, the court is going to set the matter for sentencing. How many do I have?
No.
March 20th at 9 o'clock. Ms. Hughes, you have a right to be sentenced in person. You may consent to being sentenced on Zoom. Which do you prefer?
Zoom.
Court sets the matter on Zoom at 9 o'clock, March 20th. Additionally, I am going to request a pre-sentence investigation. Probation is gonna contact you by telephone. If they cannot reach you, they will leave a message and then, mail you a letter directing you to contact them. Make sure you respond in enough time so that I can have a pre-sentence investigation on the day of your sentencing. Anything further?
No, thank you, Your Honor.
No.
Nothing on behalf of Ms. Hughes. Thank you, Your Honor.
All right, then, we're all set. Have a great day and stay safe.
Judge, do you want Mr. Sims to go ahead and zoom in now?
Who was that?
1:30. There's another one that I haven't heard from yet.
I guess so.
Thank you.
It sound like you want him to.
You caught that, huh?
Yeah, that's it. I mean, to review, did we have a? I'm ready on Williams. This is case number. Um, 154503401, Lee versus Kamisha Lachey. Oh, it might be something. Williams. Defendant is charged with one count of operating with the high BAC. Today is the day set for trial appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Kamisha Williams. Ms. Williams, ma'am, please unmute and say your full name.
Kamisha Lachey Williams.
Today is the day set for trial. Are the people ready to proceed?
Yes, today is the day set, time set for trial, and the people are not ready to proceed, but if the court allows, I would like to make a record.
You may.
Thank you, Your Honor. So while the people were in preparation of today's trial, the people did reach out to the arresting officer at the time of this incident that happened in 2015, who is now Lieutenant Myron Watkins. Based off the email and my discussion with Lieutenant Watkins, it seems that Lieutenant Watkins does not have an independent recollection of the events that happened in this 2015 OWI case. So with that being said, Your Honor, the people will not be able to proceed to trial.
Ms. Stevenson.
Thank you, Your Honor. We move for dismissal.
Court is going to grant defense counsel's motion. The people have indicated that they are unable to proceed at this time. The matter is dismissed without prejudice. Ms. Williams, we will mail you a copy of the order of dismissal for your records. Ma'am, have a great day. Stay safe.
Thank you. You have a blessed day, Your Honor.
Thank you. Ms. Stevenson, how long do you want me to wait for your client to log in?
Like a minute, less than a minute.
Ms. Let me go back upstairs to see what we need to address on that.
I don't know those orders too.
Oh, there he is.
You're ready on him or you need to talk to him?
I'm ready on Mr. Sims. Thank you very much, Your Honor.
All right, well, I'm going back upstairs. My notes are upstairs. I'll be back. I'll be on you.
Okay.
Stevenson, what was that sentencing date for Hughes?
3/20.
Mhm.
Mm-hmm.
And then what else do we have?
Mr. Wright at one, you mean this afternoon, Judge?
Well, I mean, I don't know what it's, no, this morning, but Mr. Wright is, let's see what Mr. Wright's thing said. Oh, he hasn't done anything. But when was he placed on probation?
That's what I'm looking at right
All right,
now.
we're ready. Oh, Mr. Sims isn't connected. He was placed on probation. See, this non-reporting. I fell into the trap. His first review was April 13th of 23. So he's going on reporting probation, I can tell you that,
Okay,
at the very least. Did you reach him?
I did. I spoke with him. He would be available he said in 10 minutes. So I told him to wait until 1:30 or I would call him. So
I'm here.
no,
We're
not you,
talking
Mr.
about you,
Sims.
Mr. Sims. Please don't. When was that when he said he would be ready in 10 minutes?
Oh, 2 minutes ago.
No, I'd rather him come on in 10 minutes because,
Okay, I'll call him right now and tell him to come on.
all right. Mr. Flanagan,
Yes, Your Honor.
I think I left my ink pen downstairs and I know it may not seem like I should want that ink pen, but I do because I'm switching ink pens and I like that one.
The black one here?
Yes,
Okay, I'll bring it up right now.
thank you. And look, Ms. Prajeski, I'm switching ink pens, so okay, we're gonna order me these ink pens that I bought from, I think I bought them from Target or something.
Do you have enough for now? Before I go on.
Yeah, I have enough for now.
Okay.
But I'll tell you the name of them, and then the next time we place an order, I'm gonna want those. And if they have them in blue, maybe we could check and see if they have them in blue, because I have black.
Okay.
But Miss Ritter,
Yes, Your Honor.
you can kind of go. We can tell you the dates tomorrow. It looks like most of the people are getting it looks like the people are gonna have to get a new date, maybe. I could tell you who's gonna be capious for sure is Miss Hughes. Wait,
Ms.
why?
Hughes just pled.
Yeah, okay, that didn't make sense. I didn't have my thing downstairs. You good. All right. Yeah, this is my ink pen I like. Okay, Miss Hughes just played. So that's gonna be, oh, Miss Houston, are you ready on Sims?
Yes, I'm ready on Mr. Sims, Your Honor.
All right. So
Judge,
actually,
I'll stay for the dates. I'm sorry.
say that again.
I said I'll stick around for the dates.
Okay. All right, I'm ready on Sims. This is case number 234426301, the People versus Jeffrey Sims Jr. Defendant is charged with license plate illegal use. Today is the date set for review. Ms. Stevenson?
Your Honor, I'm going to just ask the court to extend Mr. Sims' probation. He did reach out today. He has not completed the driver improvement program. I did send him that eBay information. So Mr. Sims has to do that. he reached out today to, according to registered actions, I think it's Judge Kennedy that has his tickets. And he did call that courtroom at my instruction and was told they don't do tickets. So I would like the opportunity to find out who the judge is that's
And so
actually
who
handling
doesn't do tickets?
that. Mr. Sims was told by the courtroom that he called. I instructed him to call Judge Kennedy's courtroom and gave him a phone number. The number that he reached told him that they did not do tickets.
They don't, but that's not very customer service friendly. They still could have looked up his name. Judge Kennedy used to do tickets. She does not do tickets.
So I'm happy to follow up on that and get Mr. Sims to the right courtroom today if the court would allow him to just continue to work toward compliance, Your Honor.
There's a couple of things that I have a problem with Mr. Sims. Mr. Flanagan, are you back yet?
Yes, Your Honor.
Cool. Look up Mr. Sims, judge of record. It's not Judge Kennedy anymore.
No. It's Archer.
It might be Archer.
Yes, Your Honor, Judge Archer.
Yeah. So he needs to get Judge Archer's courtroom phone number. Additionally, Mr. Hunter says that probation mailed Mr. Sims a letter that came back returned. Now, I know I said you had to make sure you give probation your current address. So, Mr. Flanagan, what street do you have Mr. Sims living on?
Let me see this case. Mendota Street?
Mendota?
Yes.
That's the street you live on, sir?
Yes, 14950 Mendota Street, yes.
Okay. Well, then I don't know why Mr. Hunter said the letter came back.
That's not the address in here.
Oh, what address is in there? I mean, you saying you looking at what, Ms. Stevenson?
I'm looking at the ROA.
Well, Mr. Flanagan, what address, what are you looking at?
It's Mendota, it's just a different house number.
Oh,
Yeah.
maybe that's the problem. Okay, well then let's make sure we get probation the correct house number.
It's 14.
Don't tell. We're live streaming on YouTube. I don't want everybody to know your address. That's okay. We'll get it. Miss Stevenson will give it to us. Okay, so that's that. I only put him on probation for 4 months, so this is the halfway point. So does he need longer than the 2 months, or?
Yes, I think so, Your Honor.
All right, so should I extend it for 4 months? I mean, extend it 2 months, which gives him 4 months.
Yes, please, Your Honor.
All right, so we'll extend the probation. And he was scheduled to get off in April. Let's extend him to June. So I'll give him a review date of June the we could do June the June 13th or June 20th. Which one does he want?
The 20th, please, Your Honor.
All right.
Much time.
We'll extend it to June 20th. And then I'm going to put defense counsel will update address. And what's Judge Archer's phone number? We might as well give it to him now because he has a pen.
Okay.
Judge Archer is 965-2286.
Okay.
Okay.
Yeah. It was name Archer, yes?
Yes, Judge Roberta Archer. That's her courtroom number. They won't tell you that they don't do tickets because they do. Okay.
Okay. Okay.
All right. All right, then you're all set, Mr. Sims. Have a great day. Stay safe.
Okay, thank you.
Your Honor. Take care, Mr. Sims. He's been sweating all day about this.
All right.
Called me 6 times today.
It's all right, Mr. Sims. It's all right.
Okay.
All right.
All right.
All right. Have a great day. Stay safe.
All right, you too.
Thank you. All right. The person on the Motorola, I think I know who you are, but can you unmute and tell the court your name? Person on the Motorola, unmute and tell the court your name. Can you call him back and see if it's him? Because, I mean, I don't know how he has to say that. Mr. Flanagan?
Yes, Your Honor.
All right, let's see who gets a new date. Did I do Hardwick? Because it's highlighted, but I don't have a line through it. What's your name, please?
Oh, my name is Paul Wright.
Mr. Wright, are you properly dressed for court?
Yes, ma'am, I'm dressed.
All right, let's turn on your camera. Ms. Stevenson, did you need to talk to him or you already have?
I have spoken with Mr. Wright, Your Honor.
Okay. Mr. Wright, turn on your camera and I'll be with you shortly. All right, so it looks like Godbold gets a new date. Hudson, I think should be a capias, but is it?
No, they were arraigned in December.
For the first time?
Just confirm. Yes, Your Honor, December 14th.
All right, so they get a new date. What about Lee and Mark? Oh, wait. Yeah, Lee and Marks.
Lee. Okay, Lee has not been arraigned yet.
Oh, because they're on my docket for arraignment. And then Marks. I know Marks capias before, but I'm trying to get them in here. So let's give Marks another date.
Okay.
And then, so those all get a new date. And then what about Ross? Wait, no, I did Ross. What about Scruggs?
They were arraigned December 15th.
So they get a new date. So I need a date where we could fit 2, 3, 4, 5, 6, 7, 8. Oof. And then Sykes is capias.
Okay.
And was Young in custody?
Nope, wasn't on the jail list. I'll call back.
Yeah, let's make sure, and then we can. Did we get a competency hearing? Competency eval?
No.
Let's see make sure Young isn't in custody. And then Mac Miller is. I'll tell you about Mac Miller in a minute. Okay, so Miss Ritter, we'll give a date, but I gotta find a date where I could put all of these. We might have to do an afternoon.
Okay, Your Honor, thank you.
All right, we'll tell you the date tomorrow.
All right, everyone have a good day. Thank you, Your Honor.
All right, you as well. All right, I'm ready on Wright. This is case number 204549901. The People versus Paul Wright. Defendant is charged with assault and battery. Today is the day set for review, Ms. Stevenson.
Thank you, Your Honor. Mr. Wright has been with limited funds, so he got terminated from eBay for not paying,
Ms. Stevenson,
for
you
non-payment.
just going right in without putting on your appearance or his name?
Wow. Okay. For the record, Your Honor, Janice Stevenson appearing on behalf of Mr. Paul Wright. Mr. Wright, sir, would you please unmute and just say your full name?
Unmute Mr. Wright. And I don't know, Mr. Wright looked like he's sitting in a whole pool of fog. Unmute your device, Mr. Wright. Oh, there you go.
It's unmuted.
Say your name, please.
My name is Paul Wright.
All right. Mr. Wright came to see me before Ms. Stevenson, and his report is identical. Go ahead.
Thank you very much, Your Honor. My apologies to the court. So Mr. Wright has limited funds, Your Honor. He does live off of disability. And he hasn't had the money to pay for the anger management. He has, however, completed 6 sessions with eBay and knows that Mr. Wright's policy requires that if he is terminated for non-payment, that he probably has to start over. So Mr. Wright has already made contact with Mr. Rice and intends to resume anger management with eBay at the end of this month. I asked him about his tickets, and he says that his tickets have already been resolved within the last month. And then, so I have not verified that. The remaining costs and fines, Mr. Wright says that his plan was to work on getting eBay paid first and then to work on the costs and fines. So
you know we only have a 2-year window, and he's already been on probation for 14 months.
Yes, Your Honor.
Okay. I mean, I was wondering. Because
so I am asking,
today
I'm sorry.
Today is his final review date for a 14-month probation.
Yes, Your Honor.
Okay, go ahead.
Gives us, so that's 10 months, right?
Okay, yeah, I'm just saying. Okay.
And I believe that within that time, Mr. Wright will be able to come into compliance, Your Honor.
So when do you want me to put him on my docket? Next time he come to court, though, he can't come to court in this fall. Whatever is going on, all of this.
Sorry about that. That was an incident. Sorry about that.
Yeah, that's a lot of incense. Now I that's a lot of incense. That's what all I'm saying is you're not coming. All I'm saying is that you're not going to come to court in this haze of fall. I can barely see your face. I can barely see your face.
Okay, I'm sorry.
Okay, so I would ask the court to continue the matter. I'd ask for the full 10 months, Your Honor, but I'd ask for review in 6 months.
Okay, I mean, I can extend them for 10 months, but you know, the closer we get to the end, the closer he gets to the Wayne County Jail.
Understood, Your Honor.
All right, let's go with 10 months. So that would put us in February of 2025. February.
Hold on.
We appreciate Mr. Wright coming in early for his court date, but maybe in the future, we're not going to do that because he was probably prepared to come at 1:30. We asked him to come early, and this is just not prepared. He wasn't prepared to come at 12:30, but we're going to continue his probation till February the 14th, 2025. And then we're going to give him a review date. 1, 2, 3, 4, 5, 6. Let's see. His next review date is August the 9th, 2024 at 10 o'clock. Anything further?
Nothing on behalf of Mr. Wright. Thank you, Your Honor.
All right, then we're all set. Have a great day. Stay safe.
Take care, Mr. Wright.
All right, that concludes the docket. We're all set.
Okay. Thank you, everybody. Bye-bye.
Bye.